Okay, each side will have 15 minutes to present their arguments. And please do not mention the names of any victims. I know this is a malpractice case, but I like to say it all the time because otherwise I'll forget. And then the time I forget, then somebody will say it. The name of any victim or the name of any children. And we are video recording, so you need to stand behind the podium and keep your voice up. If the appellant wants to retain up to 5 minutes for rebuttal, you just have to let me know and I'll try to watch the clock for you.
Thank you, Your Honor.
Okay, thank you. You're ready. If you're ready to proceed, we're ready to proceed as well. Thank you.
I would ask at the outset to retain 4 minutes for rebuttal. Thank you.
And I'm not sure if I said this for purposes of it is Garcia versus Matheson. Make sure we're all in the same case too. Thank you.
We are. Good morning, and may it please the court and opposing counsel. I'm Ryan Gambala, here on behalf of the plaintiff, appellant Jennifer Garcia in this matter. We're here today on a case about a patient's right to not have her medical treatment dictated to her by a physician, but to decide for herself what medical treatments she's going to receive. It was undisputed at the trial court that Ms. Garcia told her gynecologist, the defendant, appellee, Dr. James Matheson, DO, that she wanted to keep her ovary. This was important to Ms. Garcia because her left ovary was her last ovary, and its removal would result in her suffering surgical menopause and the sudden onset of the symptoms associated with menopause. It was her right to decide that she didn't want to experience that, and it was her right to tell Dr. Matheson not to remove her ovary. Now, this episode started when Ms. Garcia visited Dr. Matheson because she was experiencing some uterine bleeding. He ran some tests, he did some imaging, and it was determined there was a cyst on her ovary. It was benign, and now Dr. Matheson knew it was there. The treatment plan they agreed to for the bleeding was a hysterectomy. Because Ms. Garcia had previously had her right ovary removed years earlier, she was certain to make sure that the plan did not include the removal of her left ovary because of the surgical menopause. And removal wasn't necessary to treat a benign cyst. It was Ms. Garcia's decision to live with the discomfort or issues that potentially could arise related to that cyst, as opposed to living with the effects of surgical menopause, or at least it should have been her decision. Dr. Matheson's notes from the days leading up to the surgery made clear that the plan was to preserve Ms. Garcia's left ovary. Nonetheless, when Ms. Garcia arrived to Dr. Matheson's office for pre-surgical testing about a week before the procedure, the written consent form that she was handed listed possible oophorectomy amongst the procedures. The oophorectomy is the removal of the ovary. This written consent form was required by Mercy Health Standard Operating Procedures. The defendant, Mercy, was Dr. Matheson's employer. Ms. Garcia rejected that consent form, and she was told that a new consent form would be made available to her the day of the procedure. A week later, she arrives at the operating room. The same consent form with possible oophorectomy is presented to her, and again, she rejects it. So it's now known by everybody that Ms. Garcia does not consent to the removal of her ovary. Ultimately, another consent form was created, and this one did not list possible oophorectomy as a procedure that was going to be performed that day. Dr. Matheson never got a signed consent form from Ms. Garcia that listed possible oophorectomy as a procedure. Never. This is so despite the fact that Dr. Matheson himself knew that there was a high probability that the ovary was going to be removed. That's at least according to his trial expert, Dr. Asher Walsh. In fact, Dr. Asher Walsh expressly testified that ovary removal was not unexpected, or at least it wasn't unexpected to a gynecologist. Certainly at this point, Ms. Garcia was not expecting her ovary to be removed because she had told them in no uncertain terms she didn't want it removed and rejected consent forms that included it.
But counsel, and the Dr. Matheson testified, right, that he didn't expect to find Mrs. Garcia's ovary in that condition with such a large cyst. Is that correct?
That was his testimony related to his post-operative note after he learned how upset Ms. Garcia was about the ovary having been removed.
Okay.
But the pre-operative imaging postoperative pathology do not show a cyst the size of that which Dr. Matheson suggests he encountered in the operating room. But I think more to the point is the fact that regardless of the size of the cyst, I think Ms. Garcia had the right to say, I don't want my ovary removed.
Counsel, so did Dr. Matheson testify that did the evidence show that it was the cyst fully encompassed the ovary and that other parts of the body were adhered to that cyst and ovary?
Dr. Matheson testified, yes, that the cyst encompassed the ovary and that there were adhesions in the operating room. The adhesions were not an unexpected condition. That's essentially scar tissue, and Dr. Matheson knew that she had a previous ovary removal. So neither of those conditions were unanticipated. And I think that's an important point, because one of the things that we hear in this case is that the consent form has some fine print, right? And that if a physician encounters unexpected conditions during the procedure, he has the right to make medical decisions that he thinks are appropriate.
And did she sign something like that?
She signed a consent form that had that language in it. Importantly, that consent form did not list possible oophorectomy as a procedure.
Sure.
And more importantly for this conversation is that this was not an unanticipated condition. The presence of a cyst and the presence of adhesions were both anticipated conditions. Also, Ms. Garcia had both her husband and her father in the waiting room, both available, two people, in case one got up to use the bathroom or get something to eat, so that if a question did arise, despite her expressly saying at least twice before surgery that she didn't want her ovary removed, if a question nonetheless arose in the operating arena, there was somebody available on site to tell the medical team not to take her ovary.
He asked you a hypothetical. Everybody loves those.
Certainly not.
Obviously, what his testimony was that the cyst was so big and so intertwined with the ovary that he could not extricate this is what he's saying, he could not extricate the ovary to save it. What if, and your client is saying, I think, I don't care, I didn't consent to that. What if it were the situation that the ovary burst or did something during the surgery so that she could immediately die during the surgery? Are you still saying that he wouldn't have the right to remove that ovary?
Well, in an emergency condition, such as a life-threatening circumstance, I don't know that advanced consent would be obtainable, right? Because the nature of an emergency is that it's unanticipated. But that was not the case here, nor was this an emergency situation. Dr. Matheson's testimony was that this was not life-threatening. Ms. Garcia wasn't gonna bleed out. She wasn't gonna die on the operating table. What he should have done is left the ovary where it was, and she'd asked, stitched her up and had a post-surgical conversation about what her options were, and then she would have had the information to make a decision about whether she wanted to live with that cyst the way it was, or she wanted to explore another option. But as we know here, the ovary was removed before the hysterectomy was even performed, and Ms. Garcia was pushed into surgical menopause because at this point she had no ovaries.
Now, he had indicated, even though it was an emergency situation, that it could obviously lead to more problems in the future and it wouldn't resolve her symptoms that she complained of, the reason she went to a gynecologist.
The symptoms she complained of were bleeding. Now, there was testimony from Dr. Matheson that she also complained of pain. That, of course, is disputed by Ms. Garcia. But the ovary removal wasn't going to solve the bleeding. The hysterectomy was. And that's why their approved procedure that day was a hysterectomy.
Thank you.
Certainly. Now, we're here today because it's our position that 6 of 8 jurors at trial lost their way and made a decision against the manifest weight of the evidence. But before I get to that, I wanted to talk briefly about a piece of evidence that the jury didn't get to hear, and that's the testimony from one of Ms. Garcia's treating physicians, Dr. Gita-Farooz. I want to talk about the trial court's erroneous decision to exclude any testimony from Dr. Gita-Farooz at trial. Now, the decision to admit or exclude evidence is an abuse of discretion standard, meaning that the trial court's decision should be reversed where it's unconscionable, arbitrary, or unreasonable, as it was here. After Ms. Garcia is released from the hospital and a couple of follow-up visits with Dr. Matheson, she certainly changed providers. And one of the providers she went to see was Dr. Gita-Farooz. Ms. Garcia was trying to find a therapy regimen that would work for her to treat her symptoms. And so it was a combination of various therapies and medications and other things to put together to try to make her feel better. She's treated with Dr. Gita-Farooz in 21 and 22, and eventually moved on to other physicians to try to find some remedy that would give her more peace. All of this was known to the defendants. Ms. Garcia testified to it during her deposition in 2022. Dr. Gita-Farooz was on our witness list in 2022 as treating physician qualified to offer opinion testimony. She was on our pretrial statement in 2023 and on our trial witness list in 2024. Defendants requested and received those medical records from Dr. Gita-Farooz. So the 21 and 22 treatment was by no means a surprise to the defendants in this case. Now, as it turns out, Ms. Garcia ended up returning to Dr. Gita-Farooz shortly before trial to give the therapy another shot.
Counsel, you were in your rebuttal time. You can continue arguing if you want.
Maybe to summarize the Dr. Gita-Farooz argument, there was no unfair surprise and no prejudice to Dr. Gita-Farooz coming in to testify about the treatment she provided in 2021 and 2022. Even if one accepts the argument, the defendants would have been surprised by the treatment that occurred shortly before trial. Now, with respect, and I will say the part of Dr. Gita-Farooz's testimony would have gone to the significance of the harms suffered by Ms. Garcia, and therefore the reasonableness of that risk and the reasonableness of that risk being disclosed as part of obtaining informed consent, and then the breach of that duty. Now, the other assignment of error is the manifest weight of the evidence. And what I think is important in Ms. Garcia's medical negligence claims are the first two elements. That there's a standard of care and that it was breached. There's no dispute that there's a standard of care in this case. Both sides agree that Dr. Matheson needs informed consent from Ms. Garcia to perform the procedure. Dr. McCarris, plaintiff's expert, and Dr. Asher Walsh both agree that getting informed consent is making sure a patient understands the risks of a procedure. Here, Dr. Matheson breached that duty when he removed possible oophorectomy from the informed consent form, knowing that he still planned to potentially take her over, at least that there was a high likelihood of that happening. That risk had to be disclosed. It had to be disclosed pursuant to the expert testimony, pursuant to Mercy's standard operating procedure, pursuant to Ohio Revised Code 2317.54A. Dr. Asher Walsh, Dr. Matheson's own expert physician, testified that there was a high possibility that the ovary was going to have to be removed. That's a material risk. It's a reasonable risk that should have been disclosed, and Dr. Matheson should have had her informed consent in writing to possible oophorectomy. I'll reserve the rest of my argument time for rebuttal. Thank you, Your Honor.
Good morning, Your Honors. May it please the court. Brianna Verslipsky on behalf of defendant Appellees. Respectfully, I'd like to ask this court today to affirm the judgment of the trial court below, including the jury verdict in favor of Dr. Matheson. Now, on plaintiff's first assignment of error, we're here under a manifest weight analysis. And manifest weight requires a serious miscarriage of justice. It's not enough that the finder of fact loses its weight, but that it clearly loses its weight. There needs to be, substantial evidence that the jury erred here, and there is a presumption that the jury was correct in rendering its decision. The reason I say that is because we have one single determination here that was made by the jury, and that is that Dr. Matheson met the standard of care in his care and treatment of plaintiff. What that means is that a reasonable physician in his position would have acted similarly. And indeed, there's not a whole lot of dispute when it gets down to the actual surgery that took place. Dr. McCarris, plaintiff's expert, agreed that he was a good surgeon, that he performed the surgery well. He disputes, whether or not the cyst could have been removed, but Dr. Matheson, who was there, who could testify as to what the cyst, the tumor looked like, said, I couldn't remove it. A normal ovary, for reference, is about 3 centimeters large. The cyst, which was inside of it, had blown up to about 8 centimeters. So because of that, if you try to cut open the ovary to remove the cyst, what's going to happen is, you're going to shred the ovary, and then you increase the chances that that you're going to puncture the tumor, and then whatever is in the tumor, and I will note, plaintiff said the tumor was benign. That was determined after the fact. Going in, Dr. Matheson did not know that this was benign. So, I want to emphasize that. Whatever's in there is now in the plaintiff's abdomen. If it's cancerous, you were upgraded from, stage 2 to stage 3 or 4 almost immediately. And Dr. Asher Walsh, our expert witness, said, when you're looking at a surgical decision like that, an experienced surgeon is going to look at that and say, I can't, safely remove that cyst and leave the ovary. So he took both.
Did Dr. Matheson testify that he knew that she did tell him she didn't want the ovary removed?
So that's a key distinction that I want to make here. He knew that she wanted it, and it was a goal of surgery. But he said, I don't make promises, and I can't make guarantees. All of the surgeons here agreed on that. You can't make guarantees with surgery because you don't know what you're going to encounter until you're in the abdomen. There was testing done, but even the conditions that he anticipated, the adhesions, the cyst, he could not fully appreciate those and make his surgical determination until he put eyes on them.
I'm not even going to try to say the medical term for the removal of an ovary, but why would he agree to have that removed if he knew that there was a possibility he would have to remove the ovary?
So I think it's about mindset ultimately, and I almost want to, describe it as a difference in burden of proof, between a preponderance of evidence and beyond a reasonable doubt. So, in this prior surgery he had, about 2 years prior, they talked about the possibility of an oophorectomy. What happened is Dr. Matheson went in, there was a cyst, he looked at it, determined that he could leave the ovary, and he left it. So, certainly that's a case where even where he encounters an abnormality, he can, qualify that, determine what risks there are and, how it could be treated. In this case, he went in, he could not leave it in there. One, if it was cancerous, there's the chance that, cancer is going to spread. 2, any future procedure is going to be exceedingly more dangerous, because in terms of, things that he's aware of, there were these adhesions. They were significantly worse than he anticipated when he went in, to the point where he had to call in a second physician. That was Dr. O'Donnell, who testified at trial, and what was planned to be a 1-hour procedure ended up taking 3 hours. And that's significant because these adhesions are caused from medical trauma. They have other causes, but when you have surgery, the adhesions are going to get worse.
Why is it his decision? If a patient specifically says and refuses to consent to the removal of her ovary, other than an emergency situation that meant life or death, why is it the physician's decision?
Well, because he has his clinical judgment, and I think it's also, in the record, it was never really explained to him. He never appreciated that, under no circumstances did she want the ovary out. It was his understanding that it was a goal, it was something she wanted, but not that it was, a mandatory condition of the procedure.
So there was a disputed fact, because she's claiming that she said, I don't care if it's full of cancer, don't take it out.
That's her claim, but certainly there were things plaintiff testified to that were questionable. There were issues of credibility, and that was for the jury to resolve. So.
Right, but that's what I'm asking you. Did he specifically say, no, she never told me that?
He did not say that. What he did say was, it was my understanding that she knew the risks, that she knew that there was a chance that the ovary was going to have to come out, depending on what I encountered, and she agreed to that. She signed a consent form. There was no exception on the, there's 2 key provisions here. One is the one that allows him to exercise his clinical judgment, and there's a second one that would have allowed plaintiff to say, I do not want this procedure performed. That provision was left blank. There was no oophorectomy. There was nothing written there that would have made clear on the consent that she didn't want this. So ultimately, that's a credibility decision that the jury made.
Counsel, I want to ask you a little bit about the other expert, Dr. McCarris.
Yes.
When Dr. McCarris testified on behalf of Mrs. Garcia, did he say that the ovary needed to come out?
Well, so he had talked about the potential that it could have been left, but this was based off of an incomplete, understanding of what was in the abdominal cavity. I would also add, speaking of Dr. McCarris, he laid out a 4-part test for the standard of care in this case for informed consent. Does she appreciate, the indications for the surgery? Does she know about the alternatives? Does she know about the risks? And, does she understand the qualifications of the surgeon performing the surgery? And on cross-examination, he admitted that Dr. Matheson met all 4 of these requirements. That's a danger when you're giving expert testimony. If you're giving a 4-part test, you can't say that the defendant met it, because otherwise, you're saying he met the standard of care.
And Dr. McCarris, did he say that these type of cysts that Mrs. Garcia had on her ovary doesn't go away on its own and can turn into cancer?
So, as I recall, Dr. Matheson testified, with these types of cysts, if you drain them, they're gonna come back. In this case, we saw there was a cyst present in the prior surgery, not the one that removed the right ovary, but when he previously examined the left ovary, that cyst was almost half the size of the one that he removed here. So based off of what he's seeing, the clinical profile, not only are these cysts coming back, and the fact that she had them on her right ovary is an even bigger indication she's going to get them on her left, but they're coming back bigger and worse. So, based off of what he's seeing, what he's observing, the medical history of this patient, who he's seen for close to 20 years at this point, it's his understanding that this problem is not going to get better.
I guess it gets so confusing. So one of their arguments is that the jury got confused because everybody's testifying to what a wonderful job he did in removing the ovary, but the whole issue is, did she consent to the removal of the ovary, and did she have informed consent? And I guess that's where I'm having kind of a hard time trying to figure this out. So, because a lot of the discussion seems to revolve around why the ovary was removed.
Sure, and what I'd like to point you to, in our direct of Dr. Matheson, page 774, 757, there were discussions there. He said, I told her I can't guarantee this ovary won't have to come out. I informed her of the risks. He said, he made these complete disclosures to her, and at the end, it was ultimately her decision to proceed with surgery.
But the problem with that is, she asked for that part. She refused to sign. There's no dispute about that, right? She refused to sign the consent form 2 times.
Right, but we have, the consent form that controls here had no exceptions to it, and it allowed him to exercise his clinical judgment.
Even after he knew that she didn't want it removed, regardless of anything.
Well, that's in dispute. He knew she didn't want it removed. Whether, she actually told him, even if it's cancerous, she testified, even if there's a 10-foot tumor in there, it's not really clear that that was ever made clear to Dr. Matheson. And, that's the kind of testimony that perhaps, in retrospect, she felt she made it very clear. That was not Dr. Matheson's testimony. He makes no promises, he makes no guarantees. He would not have gone forward with that surgery if he knew that she, if she would not have allowed him to take it out under any circumstances. Turning to the next assignment of error, we have the exclusion of plaintiff's treating physician, Dr. Viti Feruz. And, as plaintiff acknowledged, this is a discretionary decision, and this is an expert who had been previously disclosed to us, and unbeknownst to the defendants, plaintiff resumed treatment with this physician several months before trial. We were never advised until pretty much the eve of trial. It had indeed relied upon plaintiff's prior representation that she had discontinued treatment. So when we had this last-minute disclosure of records, that's not sufficient time for us to review these records, to have our experts review these records. And
I
so,
wanna be sure I understand too, to
Yes.
clarify. So, no records and Dr. G was not allowed to testify, period.
so her billing records were allowed to come in. Plaintiff was allowed to say, I treated with her and this is what I spent. And that's significant because this is a damages expert. She was only able to testify as to what was in her records.
Right, but I wanna make sure I understand. So Dr. G, couldn't testify. Why couldn't he testify about why couldn't she testify about treating her in 21-22?
Well, the trial court noted, they simply never asked. If you, there was discussion of this decision when the trial court made that determination, and plaintiff said, you know, the key testimony here is about this new course of treatment that she's undergoing. So, you know, I think if plaintiffs had said, okay, well, you know, we won't talk about 2024, can we talk about 2021? I don't think the trial court really would have had an objection.
So was there any objection by the plaintiff in regard to all this?
Not with regards to the 21 treatment. And the trial court noted in its decision on the motion for new trial, you know, they could have simply asked and they did not. And, you know, I think the bigger picture here too is when we're looking at these decisions in retrospect, what difference would it make? Would it have made? Because the only question ever reached by the jury was standard of care. And a treating physician whose testimony is confined to their records cannot talk about standard of care or causation, especially in this case where plaintiff only saw Dr. Gatti-Farous for the first time after the surgery had already taken place. So she can't talk about any of the things that informed Dr. Matheson's procedure. Her testimony would have been limited only to damages. So as it relates to the jury's ultimate verdict, her testimony would have had no impact at all.
Were there interrogatories to the
There
jury?
were. Yeah, so the sole interrogatory that the jury answered was, you know, was there a breach of the standard of care? They said no. So because that was the only determination by the jury, having more evidence of damages doesn't really, you know, it doesn't really move the needle.
What, did the jury instructions talk about the standard of care being informed consent?
So there was a standard of care, we used the standard OJI, and then I believe there was a separate informed consent instruction.
Thank you.
But in terms of the interrogatories actually answered by the jury, the sole interrogatory related to the standard of care, and they found that there was no breach. And so, unless the court has any further questions.
I don't think so.
All right, then I respectfully ask that this court affirm the judgment of the trial court below and uphold the jury's verdict. Thank you.
Thank you.
Thank you, Your Honors. I would like to pick up, Judge Carr, maybe where you left off with regard to Dr. Matheson's testimony. I think this is important. This is transcript pages 786 and 787. It's our brief. I want to read it in. Here's the question. And then you give her a consent form that said possible oophorectomy, which she rejected because you knew she wanted to keep that ovary, right? Answer, correct. Question, she made it clear. Answer, she did. Question, those were her wishes. Answer, they were her wishes, yes. Question, and consequently, she was given another consent form that didn't list possible oophorectomy, correct? Answer, correct. Question, nonetheless, you still thought oophorectomy was possible, right? Answer, yes. Question, and you didn't disclose that to her on the consent form she signed, isn't that right? Answer, that was not on the consent form. Dr. Matheson knew under no uncertain terms she wanted to keep the ovary. There's no question. Now, we heard a little bit of conversation about a prior surgery that Ms. Garcia had years earlier, and I would submit to you that that has no relevance to this procedure, where Ms. Garcia said twice that she rejected the consent form that listed possible oophorectomy, and Dr. Matheson plainly understood that, as the testimony we just heard made clear. We also heard comment about a procedure Dr. Matheson had done in the past where he'd seen a cyst and left it, which is precisely what he could have done in this case.
I want to ask you a question about that consent form. You said that indicated the possible oophorectomy. Is that what it said, or did it say possible, or was it?
Your Honor, it said possible. So the way the consent form was prepared is there's a space to kind of handwrite in what the procedures are going to be that day. Hysterectomy was listed because that was the procedure to be performed. Initially, on the rejected consent form, it listed the hysterectomy, I believe a bladder suspension, and a possible oophorectomy. And that was stricken by Ms. Garcia. She refused to sign it. It was presented again with the same language, and it was rejected again. Then the doctor made the decision to remove that from the consent form, so it was clear it wasn't going to be performed, even possible, not even a possibility it was going to be performed. And that's the consent form Ms. Garcia signed. Now, we've heard some reference to this negative inference on the back, that Ms. Garcia should have listed on the back of a consent form on the day of surgery while she's laying in a gurney that she doesn't consent to possible oophorectomy. But the truth is, she's already told Dr. Matheson that twice, including earlier that very morning. Now, with respect to Dr. McCarris, we heard a representation that Dr. McCarris's testimony was that Dr. Matheson met the standard of care, and that is simply not true. Dr. McCarris's testimony, as put forward in our reply brief here, was that he was obligated to list possible oophorectomy on that consent form if he'd had a conversation with her about it, and if he expected it to be a procedure, which Dr. Matheson plainly did. That's transcript pages 570.
But Dr. Matheson didn't expect it to be a procedure. Isn't that where the conflict is, the question of dispute?
But Dr. Matheson's testimony is that he did expect that it could still have to be performed.
It could have to be performed. He couldn't rule it out completely. Is that accurate?
I think that is, and in fact, his own expert, Dr. Asher Walsh, testified that it was a high possibility that the oophorectomy was gonna have to be performed, and that's why it should have stayed on the consent form. And after all, that's why Dr. Matheson put it there the first 2 times around. And if he couldn't perform
Counsel, you need to summarize this.
if he couldn't perform the hysterectomy without the oophorectomy, he should have declined the procedure. It was Ms. Garcia's decision, not Dr. Matheson's. The manifest weight of the evidence supports the elements of Ms. Garcia's claim, and we respectfully request that the decision of the trial court be reversed in this manner, remanded for new trial. Thank you.
Thank you. Thank you both for your arguments to the court today. The court will take the matter under advisement and issue written opinion that will be sent to both sides, as well as you can look on the Ohio Supreme Court website. We release those electronically there as well.
Thank you.
Thank you, Your Honor.
Hope you have a wonderful rest of your day.